My talk builds really directly right on what Lisa just said, so I'll avoid all of the repetitious parts, hopefully. But maybe my talk will be a little bit more abstract. So I want to have a slightly different focus. I focus on the use of this regime to empower private business corporations through and within public international law, especially over the last couple of decades that are most of interest here. So my goal is really to expose the emergence of the multinational corporation as an autonomous lawmaker through its selective engagement with the manifold of bilateral investment treaties, BITs, foreign free trade agreements, and the European Convention on Human Rights, even, surprisingly. So, but for present purposes, because it's more interesting here, I'll focus on the international investment law aspect. In other words, the principal regime for the protection of foreign property under international law. So I've titled the talk Corporations as Lawmakers. And what I really mean to highlight specifically is the multinational corporation's emergent capacity to make international law through what's called a modern internationalized power of contract. So I'm not concerned with things you often hear about, indirect lawmaking through influence lobbying, or what's sometimes called soft law or informal lawmaking, standard setting by industry groups that are incorporated through courts, blah, blah, blah. I really want to focus on direct formal lawmaking by agreement with sovereign states. And so my argument is that through creative treaty shopping, corporations can today attain robust property-style protection of the kind Lisa just mentioned, specifically for their contracts with foreign sovereigns. And as international legal instruments, these contracts, as quasi-property entitlements, have priority over later in time conflicting national laws, including public law and regulation. So as a result, the corporation really has to be understood as something more than a mere domestic actor. It has to be understood as a true international lawmaker whose private agreements with foreign sovereigns yield dramatic consequences for domestic public law. So what are the stakes of all of this, if it's not obvious? This radical transformation of the corporation from an essentially domestic legal person into an international entity with the capacity to actually author the rights that it's subject to can only be really weakly grounded in state consent. It's often said it comes out of the treaties that states signed, but it really only comes out of a sort of very loose treaty system, and I'll explain a little bit more, loose treaty provisions. But it comes at a stark cost, a very clear cost, to the state's capacity to regulate in the public interest. A cost felt acutely by developing countries, like Ecuador especially, but no less real and potential for the developing countries, which provides some hope for amending these treaties in useful ways. It's also important to note that these powers come basically unchecked, without much in the way of commensurate safeguards on the international level. So corporations have attained a lot of power under these treaties, but no responsibilities. In fact, not even the capacity to bear responsibilities, because they're not formally usually recognized as international legal persons. So, assuming that I have as much time as I hope that I have, I want to just really emphasize two things. This transformation of the corporation has completely undermined two essential premises of public international law as relates to business. One, that all contracts are essentially governed by the law of some country, and two, that the corporation is essentially a creature of some country and is best regulated by national states and national law. The reason why we don't make corporations subject of international crimes, of international responsibility for various things, is we think the domestic state can best do this. And I want to suggest that we've already gone quite a bit of way from that position, and so we should start thinking about the more public approaches that we've avoided so far. So it takes three steps. How has this situation emerged? And I'll try to get into that most of all. It's emerged through three developments in the law of international investment law doctrine. One, regarding the status of contracts. The second, on the type of property protection involved and associated with these contracts. And third, the law of corporate nationality and the ability of corporations to forum shop for treaty protection. So let me just give the whole picture in the abstract. The idea of making law by agreement is really familiar in public international law, where the archetypal legal instrument is a treaty, binding only on the state's parties. No one would ever say a treaty is merely a private agreement between states. It's really a form of public international law, and it has dramatic effects on the populace of both of those states. So it's important to understand that treaties have dramatic effects on national peoples, and that treaty breach can't be excused by domestic law of any kind. Yet we don't normally conceive of domestic contracts as law, at least not lawyers in common law countries. Civil law countries treat it a little differently. It doesn't really matter semantically what we call them. What we care about when we look at contracts is that they really govern the relationship between two parties, or however many parties to the contract that they are. They don't have normative legal effects on the populace as a whole, usually. So I want to argue that internationally protected state contracts occupy a space somewhere between the domestic contract and the international treaty. The key point is that despite appearing as a merely private legal instrument in form, the corporate sovereign contract, its status as a heavily protected international legal instrument, significantly inhibits the contracting state's domestic regulatory freedom in a lot of the ways that Lisa has mentioned. And such contracts regulate the relationships between the parties, but at the same time create a powerful impediment on the state's capacity to regulate in areas including taxation, public health, environment, management of national emergencies shouldn't be ignored. You'd think that they wouldn't have an exception for that, but apparently not. So the key is that these dramatic public effects arise out of the implicit fusion of international contracts with domestic property theory, reaching far beyond anything tolerated in any municipal legal order of property. So let me get into the specifics. The startling image, I take to be quite startling, image of the multinational corporation as an international lawmaker arises out of the confluence of three seemingly disparate trends that I mentioned before. Recognition that state contracts are entitled to treaty protection at all, the entrenchment of an uncommonly robust level of property protection, and the non-obvious association of that protection to the contracts, because usually we think of these as different regimes, contracts and property. And third, the recognition that multinationals can alter and supplement their nationality at will to take advantage of treaties that might otherwise be unavailable to nationals of their home state. It's important to keep in mind one thing throughout all of this, though. This state of affairs is not something that's simply produced by consenting states who may or may not have foreseen all of the implications, and they might have missed a few things, but they basically agreed to this system through their investment treaties. It's emerged through a dynamic complex of action with three main actors: the states themselves, but also international arbitrators who are not accountable, and there's no system of appeal, as Gustavo mentioned. And then third, corporations who, in pursuing the profit motive, as of course you expect them to do, and can't really complain when they do it, in maneuvering around these treaties to try to accomplish more, greater, and higher profits at all times. But none of these developments really are clear consequences of any of the treaty provisions we're talking about. And I don't want to get too much bogged down into the technical details, but what should be clear is that the 3 or 4 words, fair and equitable treatment, shouldn't necessarily imply that a contract between a state and a corporation should be entitled to a more robust form of property protection than any state property regime would know. And that's all you get, those 4 words, fair and equitable treatment. It gets interpreted into this massive entitlement by unaccountable arbitrators. So it's important to understand that the whole time you'll always hear that this is a product of state consent, but that's something we should really challenge. So the first development, the form of lawmaking through an internationalized power of contract. It's something that in the oil arbitrations in the 70s we sort of flirted with in some arbitral systems, but it really didn't enter the mainstream until the modern bilateral investment treaty era. The modern mechanism really lies not in general international law, but through operation of a web of very specific treaties between states for the protection of foreign investments, and not just bilateral investment treaties, as I said, but also human rights treaties, which we think of as much more favorable to rights, sometimes are used in this way. And all of these treaties, the lowest common denominator is that they grant states certain very ambiguous protections, investors certain ambiguous protections, and give them the tools to directly enforce those protections through binding international arbitration. The treaties are at their core instruments for protection of foreign property, but they've been extended to contract protection in a few crucial ways, with the result of converting qualifying investment contracts into instruments of international law. So whether we use the terms internationalization, treatification, whatever it is, none of these terms are ever in the treaties. The key point is that these treaties insert qualifying contracts into the international legal hierarchy and insulate them from breach by contrary domestic law of any kind. And that's really the core point, because you really wouldn't expect, even in a domestic system, a contract to trump, public legislation. So I'll avoid getting into the specifics of exactly how they do this. I'm happy to answer that later, but it's a long story and it's complicated and it's never the same because, again, the tribunals are always different. But the key point is that as long as a state contract can be characterized as an investment, which most can, short of maybe a sale of goods treaty, according to basically most of the treaties, these contracts will be given the full status of protection under fair and equitable treatment, whatever that means. The problem is that whatever that means doesn't get filled in from contract law. It doesn't get it gets filled in, not really explicitly, by a sort of second development in international investment law, a theory of property protection that's incredibly strong. And again, I won't get into it too much, but it's important to note that it's not just a problem that this level of property protection is incredibly powerful. It's a secondary problem that it's then ascribed to the protection of agreements between states and international actors, investors. So rather than reiterate all of these nice points that I had on the problems with property protection that Lisa has already covered completely, I'll turn to the third trend. That even accepting that corporate sovereign contracts are really best understood as a source of international law, it doesn't necessarily follow that corporations should be understood as autonomous lawmakers. And it sounds like a theoretical point, but it actually has pretty important implications. So, the objection would be a corporation exists by grace of a particular state's law of incorporation, and it gains access to the international treaty protection only by operation of its state of nationality's treaties on foreign investment. So to the extent that state contracts are a source of law at all, one might be tempted to view the corporation's lawmaking capacity as merely derivative of or delegated by its state of nationality through its home state's network of treaties. But I want to make clear that the corporation's capacity to make law through these contracts can't be reduced to a merely derivative or delegated power dependent on the treaty arrangements of its home state. The multinational corporation's flexible form allows significant leeway to acquire treaty protection for its contractual commitments far beyond the scope of the treaties ratified by its state of nationality. And the secret lies in its capacity to alter its nationality by simple reincorporation or even incorporating wholly owned subsidiaries to take advantage of an enormous range of investment treaties to which the parent corporation wouldn't otherwise have access. And this is basically 100% clearly recognized in the doctrine that they can do this, which is very rare in investment law. So a series of arbitral awards in the last decade basically said that they indicate that tribunals are deeply unwilling to look through corporate subsidiaries in assessing whether they qualify as nationals of a state party to a particular bilateral investment treaty, absent extreme abuse. But that doesn't really happen very much in law. So just as an example, to use another state not present here, even though the United States has no bit with Venezuela, a U.S. corporation can easily attain international protection for its contracts with Venezuela by simply structuring its investment through another state, like the Netherlands, who has a very, very, very nice set of bilateral investment treaties, very protective ones with the Netherlands, with Venezuela and many other states. It's something affectionately called the Dutch sandwich by lawyers who work at law firms that do this, which I may have worked for myself. So the trick is, though, you don't have to structure your investment in that way in advance of actually making the investment. Chevron can create a subsidiary, can create an investment contract with Venezuela, and then maybe they get the sense that Venezuela has been expropriating some other people's things, as they do sometimes, and then say, okay, well, I see the writing on the wall, now we're going to reincorporate and literally unilaterally change the law of the contract from whatever it was originally, let's say Venezuelan law, to international law, whatever that means. So it's pretty amazing that they can do this after they've actually made the investment. And you have to understand it's a unilateral thing. Only one party has the right to decide ex post what the law of the contract is, with major effects, because if the contract was just under Venezuelan law, you wouldn't get all of these robust protections, property-style protections. Once Venezuela breached that contract, you'd get whatever Venezuela said. As soon as you internationalize it and send the thing to international arbitrators, the story's very, very different. So I assume I only have about a minute, so I'll sum up. If the form and the substance of corporate lawmaking comes from a blend of contract and property ideas, then what I'm suggesting is that the autonomy of the corporate lawmaker arises out of arbitral doctrine on the law of corporate nationality. The full image of the corporation's status as a lawmaker in international law doesn't really come into focus through analysis of any of these trends on their own. And these trends aren't really viewed together very often. But taking them together, we see a much more recognizable image. At least within the ambit of the pre-existing web of international investment treaties, the corporation appears as a basically autonomous actor empowered to make and directly enforce international law with major effects on the domestic regulatory freedom of its contracting partners. And there's a lot of problems with this. I'm happy to talk about them more later, but the main three are, first, that we should be much, much more suspicious of the level of property protection that's given rise to this situation. And second, we should be especially suspicious about associating that level of property protection with state contracts. And third, although it is a rarity in investment law to find consistent doctrine on corporate nationality, we should be suspicious of the idea that one party would be able to change the terms of the contract unilaterally for reasons outside of that contract, simply by reincorporating in another state. There's a lot of other problems, but I'll leave it to another day. Thanks very much.